Do we need a few minutes?
We do have Mr. Richard that is on Zoom. He's listed as the authorized representative of Devontae Richard.
Devontae Richard matter 2A04000092 and 2A04000113. Richard, if you could activate your audio and video so I know that you are hearing. Okay, thank you. The case that we believe I saw recently, there was a eval set up and they were unable to reach him to participate in that evaluation.
That's my understanding, Your Honor. I saw that as well. I think the last time we were in court, counsel indicated that the meeting had been set up to do the evaluation and the date was discussed. And it looks like Mr. Richard did not appear for that.
And for the record, Sean Parent for Mr. Richard. Yes, unfortunately, that appears to be the case. I'm not sure why Mr. Richard didn't appear at the evaluation.
So, Mr. Richard, we've been waiting for you to talk to one of the doctors, and we've been setting this case over for that to happen. When you were here on April 8th, we discussed that you were scheduled for that appointment on April 24th. So I know that you were aware that they had you calendared. Mr. Richard, why didn't you show up for that appointment?
Well, that was an assumption. I wasn't aware of anything.
Well, you were at the hearing when we talked about it, so.
Welcome to one of the most baffling courtroom moments you'll ever witness. The case of Devontae Richard, a self-proclaimed sovereign citizen who believes he's merely the authorized representative of himself. Yeah, that's already a red flag. This hearing starts off with confusion and ends in chaos as the judge tries patiently to get a basic competency evaluation done. But Richard's logic sends this proceeding off the rails. Stay tuned, because this isn't just about traffic violations. It's about watching the clash between reason and delusion unfold live in court.
Participated on Zoom on April 8th, and we discussed that your evaluation was calendared for the 24th of April.
Was there anything signed for confirmation?
Your attorney has been working to get that set up. So.
Well, I haven't talked to anybody.
Mr. Parent, have you been in contact with Mr. Richard?
Looks like my office, we tried to reach him to make sure that he appeared at the evaluation, but we were unsuccessful in reaching him.
Do you have proof of that?
Yes, I have my colleague's notes that we tried to get a hold of you.
And what was the number?
So, Mr. Richard, we have the phone number that ends in 1752.
I'm talking about the number you supposedly contacted the defendant on.
Yeah, you're the defendant, and it's the phone number that ends in 1752.
No, that's an assumption and presumption. I'm not nobody's defendant. I'm authorized representative.
Right here, we're seeing the very first warning sign. The judge calmly reminds Richard that he personally attended the last hearing where the evaluation date was set. Instead of acknowledging that, he throws out the classic sovereign line. That was an assumption. This is the kind of wordplay sovereign citizens love. They twist ordinary communication into imaginary legal loopholes. But judges have seen this act before. When Richard claims I wasn't aware, despite clear proof he was told, it's not confusion, it's obstruction. The court's patience is thinning, and we're not even 3 minutes in.
So, Mr. Richard, the thing is, if you cannot participate out of custody, the court may have to set bail and have you placed in custody to get this evaluation accomplished. So when you are informed of the appointment and then you choose not to appear, the court interprets that as a willful violation.
Under what law are you saying that I could? What charges? What are the charges?
We've gone over that. You have been told that you are charged with driving while license suspended and driving without an ignition interlock device. So I understand you disagree, but at this point we need to.
I don't disagree with none of the facts. I said, what was the date?
The date of the driving? Is that what you're asking?
Well, I don't drive, so I'm trying to figure out the date you have on file.
June 4th, 2022, Your Honor, is the charge date.
Thank you.
Okay, and have I been charged with anything?
Yes.
And what is it? What are the charges?
As the court just read aloud, driving while license suspended and driving without a functioning ignition interlock.
And is there a witness that you can bring?
And here it is, the moment every courtroom commentator knows is coming. Richard declares he's not the defendant, just the authorized representative of that account. This is Sovereign Citizen 101, separating the flesh and blood person from the legal identity, as if it's two different beings. What he doesn't get is that in a real courtroom, you can't opt out of your own legal responsibilities. The judge tries to explain that even if you call yourself an authorized representative, you're still the defendant. But to Richard, that's just an assumption.
The criminal charges, you also were cited for not having insurance.
Yeah, but do you have a witness?
Yes, the city has witnesses. We have the officer that will be testifying.
The officer. Okay, well, can you read the police ticket on the record?
We're not having a trial today. We're trying to figure out whether or not you are competent and able to proceed in this matter, and that requires that you speak to a doctor. But that is what we're trying to accomplish. And Mr. Richard, if you refuse.
Can you explain to, I don't understand. So can you explain to me how
We've
how this works?
explained this to you previously. So what I'm going to ask you is whether or not you are going to comply with meeting the doctor out of jail, or does the court need to set bail and have you booked into custody so they can talk to you there? That's not what I'm wanting to do. I would like you to cooperate and have this case proceed with you out of custody.
Well, I need some type of contract to obtain to whatever you're asking, because I have questions and you're not answering them.
Your Honor, at this point, I think given the track record of Mr. Richard and his unwillingness to comply, the city is going to be asking that the court set bail and remand him on that bail to have the evaluation done in custody.
Mr. Richard, can you assure the court that you will come to an out of custody evaluation?
I will agree to anything if you guys can tell me the nature and cause of this action. My Sixth Amendment right. I need to know these things.
Notice how Richard interrupts with "under what law?" A classic stalling tactic. The judge lists his exact charges: driving with suspended license and without an ignition interlock. Simple enough, right? But instead of responding, he pivots to "I don't drive" and starts fishing for dates and witnesses like it's trial date. Here's the thing. This hearing isn't about guilt or innocence. It's about whether he's mentally competent to stand trial. But Richard treats it like a cross-examination of reality itself.
I didn't quite hear your question. What are you asking?
I need to know the nature and cause of this action. I need to know that before we can move forward.
Yeah, I believe that the court has told you that you're being charged with driving a license suspended in the third degree and operating a motor vehicle without an ignition interlock device.
Okay, well, I have a question for the judge.
What's that,
Hello?
Mr. Richard?
Hello?
Mr. Richard?
Hello? Or can you hear me?
Yes, I can hear you. You should sit down, and then instead of having me facing you at the clouds, you should participate in this hearing. Thank you. So every time we have a hearing, you ask these same questions, and we've explained to you that you're facing criminal charges and that we need to have the doctor speak to you. And so right now, your option is whether or not, as your attorney said, you can agree.
This is a turning point. After minutes of circular logic and refusal, the prosecutor finally steps in politely but firmly and asks for bail to be set. That's the courtroom equivalent of waving a red flag up until now. The judge has been trying to keep Richard out of jail by letting him complete the evaluation voluntarily. But his constant demands for contracts and nature and cause speeches make cooperation impossible. You can actually feel the courtroom energy change here. The patience is gone. The tone hardens. And from this moment on, Richard's fate is sealed.
To meet with the doctors and stay out of jail to do that, or the court will have to remand you into custody. so that they can
So
talk to you
basically,
while
you're
you're
telling
in
me you're
jail.
refusing to answer me. You're refusing to answer any questions? That's what you're saying? Because I just have questions.
We've answered your questions. We're going to proceed at this point. I'm going to.
I
it
didn't
does-
even answer. I didn't even ask the question. So how did you answer it? That's what I'm saying. Are you refusing to answer the questions?
What do you want to know besides what you're charged with? What was your other questions?
My other question was, did you or did you not take an oath to uphold the Constitution? Can I just get a yes or no?
That would be a yes.
So you're enforcing statutes right now, and so you're totally going against your oath. So I'm trying to figure out what authority do you have to tell me to do anything as a public servant?
Mr. Richard, I am authorized by the revised Code of Washington to sit in this court. I'm duly appointed to be a municipal court judge. I've taken my oath. You're charged with a violation
if you
of
took
the
an oath,
RCW and the Lake
if you
Forest
took
Park
an oath, then
Municipal
why are
Code.
you why are you enforcing statutes?
And here comes the most predictable sovereign move of them all, the oath trap. Richard asked the judge if she took an oath to uphold the Constitution, which of course she did. Then he hits her with a pseudo-legal gotcha line. So if you enforce statutes, you're violating your oath. This argument sounds clever to internet conspiracy theorists, but it collapses instantly in court. Judges are literally sworn to uphold both the Constitution and the laws made under it. Richard isn't exposing corruption. He's exposing that he doesn't understand basic civics. The judge handles it with remarkable restraint, but you can tell she's running out of patience fast.
It applies to you, but it does. So
I didn't say it didn't apply to me.
I'm
I
going
didn't
to
say it
set
didn't apply to
bail
me.
in this matter at
You're making
$10,000.
assumptions, ma'am. You're making assumptions, ma'am. I never said it didn't apply to me. But we both know here that the Constitution is not for me. It is for the public servants. So I don't know why you're making assumptions and presumptions. All I had was questions, and you're just going around me.
So, Mr.
Obfuscation
Parent,
is
I'm
a
going
big
to
thing
set
now.
bail at $10,000, and we're going to end this hearing, Mr. Richard. You can report to jail. You can come in, but we are trying to do this without you having to be in custody, but you are refusing to cooperate.
I didn't refuse anything. I was never put on notice, so I didn't refuse anything.
Oh,
Everything you're doing
I know
right
you
now
were
is
put
because
on
you want to
notice
do
at
it.
our last hearing, so that's on the record. So
What's
I
on the
know that
record?
to be false, Mr. Richard. So that
So
is the status of this case.
everything that I asked you, am I wrong? Is that
Yes,
what you're saying?
yes, you're wrong. So we're
I'm
going to
wrong.
this and we are done on this matter. Mr. Parent, if he does reach out to you and something can be arranged for them, but right now the doctors have tried twice to contact you and you've taken a spot that would have been available to someone else. So we need to progress this matter and that bail will be set and we'll continue with an in-custody hearing date when you are booked.
For the record, the judge is willingly going against public policy. So on here and in, you're held liable for everything you do from here on out.
All right, thank you, Mr. Richard.
For the record.
And that's it. The judge has had enough. She calmly states, bail is set at $10,000. No shouting, no debate, just the sound of authorities shutting down nonsense. Richard tries to backpedal, saying, I never refuse anything. But it's too late. The record shows he's been warned multiple times, missed evaluations, and refused to cooperate. What's fascinating is how sovereign citizens always believe they can talk their way out with magic words, assumption, presumption, nature, and cause. But in real life, those words don't free you. They just prove you need that psych eval after. And there you have it. What started as a simple traffic case spiraled into a full-blown legal train wreck. Devontae Richard turned a suspended license charge into a jail-worthy standoff by refusing basic cooperation. The judge remained calm, fair, and professional throughout, but she wasn't about to let legal fantasy override courtroom reality. This case is a perfect reminder. Confidence is a defense, and YouTube law won't save you from real-world consequences. If you found this case as wild as we did, hit that like button. Drop a comment about your favorite jaw-dropping moment. And don't forget to subscribe for more real courtroom breakdowns and sovereign citizen fails.